Hello, class. Welcome back. This is Professor Watson, LGLA 1351 contracts. This is week 3, right? So this is we're on chapter 2 this week. So this is our first recording of chapter 2, week 3. So week 3, recording 1 on chapter 2. First, excuse me if I look a little deathly or if I sound bad. I've got a little bit of COVID this week, so I'm glad that you all are on the other side of the camera and that we're not doing this in live. But this way, at least we don't miss a class. This week, though, we're getting into chapter 2. Last week we talked about what is a contract, right? We talked about the 4 elements of contract, right? We said it was 4: agreement, consideration, mutuality, and then capacity, and then legality, whether you consider legality a condition or an element. That's really semantics, right? All five of those things always have to exist. And so I mentioned we're going to recite those every single week to get them into your head. Okay, so an agreement, agreement, consideration, mutuality, legality, and capacity, or capacity and legality, whichever way you want to do it. And so we're starting from that foundation, and that's a great place to start. And next week we'll start talking about element 1. We'll start talking about an agreement. That seems very simple, but I can't tell you how many cases I've seen lawyers win or lose because they forgot to go back to basics. They forgot to go back and establish the existence of each and every element of their case, right? In a breach of contract case, if you can't establish all 5 elements, then you lose. Or if you're the defense, if you can disprove one of those 5 elements, even just one, then you win. And so if you can prove that there was no agreement, then you win your case. If you can't prove that there's an agreement, then you lose your case. And so it'd be great to start with element 1. But before we do that, let's talk about chapter 2. Let's talk about the sources of contract law. I know we talked a little bit about the source of law generally in the introduction, right, in our first week, even before chapter 1, about constitutions and legislation, those kind of things. But this week, let's specifically talk about some sources of contract law because it's very important. We're going to talk about some really specific differences. Like here's kind of a summary of the chapter. The majority of contract law comes from common law. It comes from those case law decisions that have been handed down over decades and decades, and even over a century. And that's really what most of our contract law is based on. Okay. At the same time, contract law can be governed by statutes, and there's a lot of statutes out there, hit or miss, that might affect this contract or might affect that contract. Banking laws, right, or lending laws, or real estate laws, those kind of things. But there's one very important statutory scheme that you need to know about. That it's called the Uniform Commercial Code. It's a set of laws. We'll talk more about it, but it was a set of laws designed specifically to kind of coordinate the contract law among each state, so that we didn't have 50 different sets of contract law across the country. It was again a uniform law, a law designed to kind of bring some consistency and bring all that together. The important thing is that the common law and the UCC don't always agree. They don't always have the same rules. They don't always come up with the same conclusion. And so you need to know when the common law applies and when the UCC applies, because sometimes you can have 2 contracts that look very similar, but if the UCC applies, then the law goes one way, and if the common law applies, then the result goes another way. Okay, so it's important that we understand that difference, and then we'll spend the rest of the semester analyzing things quite often about, well, here's the result under the common law, and then if the UCC is different, then here's the different result if the UCC, the Uniform Commercial Code, applies. Okay, so we'll get into those in just a minute. For starters, I hope you've already read chapter 2. Also, you should be able to find my lecture notes. They're in our course materials. They should be attached to a link at the bottom of the video. They look something like, see if I can put it up on the screen. There we go. They look something like that. I'm not going to leave them up on the screen because you have a link to them, but just to make sure you're looking at the right thing, right? So that's my lecture notes for chapter 2, and then obviously the PowerPoint, I'll have it up here on the screen in a minute. But if you want the PowerPoint separately, it's also in a link below to the bottom of this video. It's also in your course materials. Okay, so let's get started. Let me see if I can get that PowerPoint up on the screen. So again, chapter 2, we're talking about the sources of contract law specifically, right? And again, as I mentioned, the very first source of contract law, the very first thing you're going to think of, the default that you're going to think of when you think of, oh, what law applies to this question? Once you identify it as a contract law question, is the common law. Okay, the common law. That's that tradition that we brought over from England when Europeans first came to this country. When we were setting up judicial systems, we inherited that. And although we've had a couple hundred years now to work on that, we still look at those traditions coming back from England, and that we are a common law country. You don't need to research back that far. If you find a case and you want to make sure that that case is interpreting the case before it properly, great. That's being tenacious. And if you want to make sure that that second case really cited the case before it properly, great. But you definitely don't need to go all the way back to England to make sure that that basis was the same. Our common law traditions diverged a couple hundred years ago, and their law has certainly changed since then, and ours has too. It'd only be the rare case, something really unique, something really just old and cryptic that hasn't come up where you would ever need to go back that far. So in general, we're talking about researching the common law, those judicial opinions handed down by American judges, right? You find those in the case reporters. If you're going to the law library, if you're taking my legal research and writing class, then you'll know how to go to the books. Otherwise, you would find those in Westlaw and Lexis and those kind of things, right? And from the beginning, the common law really controlled contracts. That was really our primary source of law for contracts. And it still controls several areas of the law, okay? First of all, I'd start by saying, and I guess it's not on here, but the common law is the default. If you're not sure what law controls a particular contract law question, then the common law is your default. Start there, right? Worst case scenario, you start searching common law. When you find that issue discussed in a case, they say, well, here's the statute, right? But in general, common law controls, and it still reigns supreme in certain areas. Like your book mentions, in contracts involving intangible property. Intangible, in is a prefix, of course, that means not, right? And tangible means touchable, concrete, right? Physical. So intangible property. What is intangible property? Well, things like intellectual property rights, right? Copyrights and those kind of things, patents, trademarks, trade secrets, those kind of things. Things that you can't touch, but we still think of as having value, right? Taylor Swift, right? She has intangible property rights in all of her songs. That was a big issue a few years ago when she re-recorded everything. Right now, everybody's re-recording everything to make sure that they maintain their intangible property rights. That's related to intellectual property, of course, copyrights, patents, trade secrets, those kind of things. And basically, as I said, the common law applies when no other law has developed to take its place, when there's no statute that overrides the common law. Okay, so as a default, the common law applies unless there is a statute that specifically overrides the common law. All right. Where do you find that common law? Well, again, the case law from the relevant jurisdiction. Okay, and that's an issue you can take up in your legal research and writing class. So, what jurisdiction do I look at? Is this a federal law? Is it state law? If it's state law, what state? Is it Arkansas? Is it Texas? Is it Nebraska? Is it California? What state law applies? And that's an issue of jurisdiction. And those are things that that really probably are more an issue of another class, but those case reporters from your relevant jurisdiction, right, or your computer-aided legal research, that's CALR. So for us here in Texas, you're going to be looking at those Southwest reporters, right? Or you're going to be looking at cases with those Southwest reporter citations on Westlaw, on Lexis, on Google Scholar, those kind of things. So that's the first place. I mean, that's the place you find common law directly, right? When you go to the primary source, right? We talk about that in legal research and writing. Your primary sources, when you're going to the horse's mouth, that's the reporters, whether they're in the book or electronic. That's what the judges actually said. That's what they wrote. That's what the common law is. But that's not the only place to find common law. In fact, sometimes common law is very hard to find unless you know exactly what you're looking for, right? Unless you have the exact term, unless you already know a good bit about this area of the law, you may not know enough yet to go start keyword searching in Lexis or in Westlaw. You may not be able to go straight to the reporters. You may need to learn something about the area of law first. That's where some of these secondary sources can be terribly helpful to help you find the common law. The first secondary source that your book mentions is the Restatement of Contracts. The Restatement of Contracts. And they're in there, what, second or third edition now? What is the Restatement of Contracts? The Restatement of Contracts is not the law. Okay, it's not the law in any given jurisdiction because it wasn't written by, well, it's not a judicial opinion. It wasn't written by a Supreme Court or a Court of Appeals. The Restatement of Contracts was prepared by an academic group, the American Legal Institute. It was a collection of legal scholars, judges, and lawyers and professors, and they came together and they said, you know, it's getting hard to figure out what the law is in any given place. What can we do? And so, so over a lot of time, a lot of very hardworking, very smart, very experienced legal professionals went out and they surveyed what is the contract law across the United States, right? Because we inherited our common law tradition all from the same place. And so they wanted to look at where is the law the same across the 50 states, right? As it has developed, what have we settled on? What are the actual principles of contract law that every or at least most states have settled on? And then they put that into something that they called the restatement. They restated, here's what the law is. After our review, here is what the law is. So for instance, there's a section in the restatement on what are the elements of contract, right? And I forget how they number it, but I guarantee you that it contains agreement, consideration, mutuality, and capacity. And that it probably includes legality as a condition, not an element, but nonetheless, that'll be mentioned in there because that's the same across all 50 states. Now, the restatement also points out when there are things that are different. So it drops all kinds of footnotes and all kinds of detailed information about where the law is a little different. So it will give, here's the general statement of the law as we find it. And then it'll drop footnotes and say, like, in this state, here's a specific statement on that issue. And in this state, here's a specific statement. In this issue, and in this state, it's a little bit different. Here's the case. So that is the Restatement of Contracts. Now, it is, again, important to understand that it is not specifically the law in any given jurisdiction. This is not something that was put together by the legislature and passed by the legislature and signed by the governor. No, it's an academic document, but it's a general statement of the law. Again, it's this summary of the consensus of judge-made law that was prepared by these academics. So it is not controlling, but it is highly, highly, highly persuasive. Unless you have a statute or a specific case that says something different, if you cite the restatement to a judge, there's a good chance, they don't have to follow it. Again, it's not controlling, but there is a good chance that the restatement will win the day because it is so well respected. It's been around for so long. And it's been so extensively used. In fact, now they're on I believe the third edition, the Restatement of Contracts third. It's organized by individual topics. So you can look up things like, we've already learned there's 5 elements to a contract: agreement, consideration, mutuality, and they'll have topics in the restatement on all those things. It's a multi-volume set. So there's a lot of information you can gain there if you don't know enough to go straight to the common law, right? If you don't know enough to go straight to those keyword searches, you can go to the restatement and you can learn generally about this area of the law and even get some real good details to help you start to figure out what you need to search, right? At the very least, it'll give you the keywords and the ideas that you need to start searching. But again, as I mentioned, they've got citations to case law in every state, or on most states, on just about every topic. So you may even be able to find a case in your jurisdiction to get you started if you go to the restatement. All right. Obviously, there's a lot of other secondary sources that you can use, but the restatement of contracts is a biggie to help you find really any law, but especially common law on contracts. That is in contrast to some statutory sources of contract law. And the gorilla in the room is the Uniform Commercial Code, the biggest, really the best well-known, the most important probably of all laws that deal with contracts is the Uniform Commercial Code, the UCC. So what is the Uniform Commercial Code? Let's talk about what it is not, first of all. Technically, I've got, you can see I've got that in all caps and in parentheses there. The UCC is a secondary source. It's much like the restatement of contracts. It is an academic resource. It is not a statute itself. Okay, the UCC, like the official, the original UCC as it is drafted, is again created by the ALI. Remember them from the restatement, but also in conjunction with the National Conference of Commissioners on Uniform State Laws. And the UCC was an attempt, whereas the restatement was an attempt to go out and examine what the law is and then restate it so that everybody knows. The UCC was an attempt to restructure, to create a better law. Okay, so it's actually again an academic effort by professors and judges and lawyers, but all in an academic setting where they sat down and they tried to create a better law. They tried to create a better, more reasoned, more just formulaic a set of laws to govern contracts, specifically in order to assist in commerce. Okay, and that's important to understand. In fact, if you understand if you understand what the purpose of the UCC was, it will help you understand when it applies and when it doesn't. Okay, the UCC was designed to facilitate commerce, to make commerce easier. Okay, so between merchants, between people who actually engage in commerce every day, the UCC was a set of laws designed to kind of take all the practicalities, take all of kind of the trade usage and recognize how business is actually done, and make it easier for merchants who are in business of buying and selling things to do that easier without having to go talk to their lawyer every time they had a question, right? Or without having to go to a lawyer every time they cross state lines into perhaps a different jurisdiction. Okay, so the UCC was the idea of the ALI and the National Conference to put together this one set of uniform law and then to offer it to the rest of the country and to say, hey, every state, here is what we think is this is the best law, the best set of laws that we could write. And so we offer it to you and we suggest that you all adopt it. Okay, so the UCC is not the law of any state. The UCC is actually written by ALI, and it's a suggestion. Okay, but every state in the country has adopted at least some portion, at least some form of the UCC. All right, so the UCC is an academic document. The Texas UCC is the version of the UCC that Texas has adopted. The Arkansas UCC is the version of the UCC that Arkansas has adopted. So now that may seem a little weird. You say, well, it's a uniform law, but it's not the same in every state. Unfortunately, yes, that's right. Now, most states that have adopted it, they adopt 90-something% of the language that they adopt, and they may choose not to adopt parts, but of the parts they adopt, they usually keep most of the language the same. But I don't think there's any state that has adopted the entire UCC without making any changes. We're in Texas right now, for instance, right? We all know Texas, we're always smarter than everybody else. Our legislature can never leave well enough alone. So even though the UCC is drafted by these hundreds, thousands of years worth of legal experience between the judges and the lawyers and the professors that put all this together. And yet the farmers and the school teachers and the businessmen who are in the Texas legislature figure, well, they can make it a little bit better and they can make their tweaks. Okay, so that's important to understand. If you've decided that the UCC applies to your particular legal question, you need to make sure that you're looking at the right UCC. If Texas law governs your contract, then you need to be looking at the Texas UCC. If Arkansas law governs, then you need to be looking at the Arkansas UCC. California law, look at the California UCC, right? So it's important to understand that even though we call it the Uniform Commercial Code, it's not particularly uniform, okay? There's at least slight differences in every state that has adopted. Now, let me throw the PowerPoint back up. That can create some headaches for legal professionals. So I've given you a couple of resources that are extremely helpful. Let's start with Cornell Law School. You've got a website right there. Cornell Law School does an excellent job of tracking what version of the UCC states have adopted and what changes they have made. Okay, so if you've been practicing in Texas and you've been working here 10 years and you've gotten very familiar with the Texas specific version of the UCC, but now you have a case that involves Ohio law and you need to know, you need to know how or if Ohio's version of the UCC differs in any way from the main UCC, then that Cornell Law School website is an excellent version of it. Okay. It's also important to understand that the UCC is periodically amended. Every few years, the ALI and the National Conference, they get together and they examine how is the UCC working across the states. Is there something that the states don't like? Is there something that has been working in court well? Are there things that haven't been working? And they will sit down as a committee and they will make subtle changes to try to make the UCC work better. And when they do, they will issue the latest version of the UCC. And again, when they do, it takes time for that to trickle down, right? Even if the ALI makes changes this year, well, Texas is going to have to consider whether they want to adopt those changes, whether they want to put those changes into effect, whether they're happy where they are. And so, as you can imagine, it usually takes a few years for those changes to trickle down to every state. So it is important to know your state's version of the UCC and to know if you're looking at another jurisdiction, what changes that jurisdiction makes, okay? The Texas version of the UCC is very easy to find. It's found at Title I of the Texas Business and Commerce Code. So anytime you're looking for the UCC, as long as we're here in Texas, right, you want the Texas version. In fact, I probably won't keep calling it the Texas UCC. We'll just talk about the UCC. But understand that normally in this state, we're probably talking about the Texas version of the UCC. And so you need to be able to find that. It's Title I, right at the beginning of the Texas Business and Commerce Code. If you can just remember that the Texas UCC is in the Texas Business and Commerce Code, then you can find it every time because it's right there at the beginning. But before I turn the page, if you want to go ahead and write down or copy that link, that is a link directly to the statute. That's at statutes.capitol.texas.gov. That's a great resource for all Texas statutes, right? It's just it's published directly by the legislature, and it is the quickest and easiest free place to find the Texas statutes, right? That's coming straight from the horse's mouth. So copy that link down, save it. You'll use it for the rest of your career, quite frankly. But let's talk about the UCC. The common law, remember we said that's kind of the default, and the common law, you can always just assume the common law applies if no other statute does apply, right? The UCC is different though. The UCC only applies in certain situations. And again, that's where I told you it's, if you understand what the purpose of the UCC was, then it will help you understand when the UCC applies, okay? So the UCC is meant to cover commercial transactions, okay? Commercial transactions. Transactions by and between people who are in the business, okay? Between merchants. So so the UCC is meant to cover contracts with Walmart and FedEx and Kroger's, right? And the grocery store and people who sell things as part of their business. Professionals, right? Professional sales companies. The UCC is meant to govern that. It is not meant to cover just consumer transactions, just between individuals, right? So if so we'll talk about this much more as this week, and then also as we go through the semester. But if you go buy a car from a car dealership, right? A car dealership is in the business of selling cars. The UCC is going to apply to that transaction. But if you want to come buy a used car from me, that's just two private individuals, and the UCC is not going to apply because neither one of us are merchants. We're not in the business of buying and selling cars. And so in that situation, even though it's still a sale of a car, if you want to know what law governs, you're going to have to go back to the common law. All right. We'll talk a lot about more of that as we go. The UCC itself is organized by topic into several different articles. Article 1 is just some general definitions and sets some general context. Article 3 is the big one, right? Article 3 governs sales contracts. Most of the time when people talk about the UCC, they're not even talking about the whole thing. They're talking specifically about Article 3. Article 3 governs sales contracts, and that's mostly what we're going to be talking about this semester. When we talk about does the UCC apply, we're going to talk about it in terms of sales contracts. Okay. Again, the primary function of the UCC is to govern commercial transactions, and it's important that we understand what that is. That's the sale or the lease of goods in commerce by or between merchants and or consumers. Where would you find that? You find that in Chapter 1. Right, or you find that in Article 1. The UCC applies, or in Article 3, as it applies to sales, it applies to the sale and lease of goods in commerce by or between merchants and or consumers. That's a lot, and we'll break that down more as we go. But what that means is, again, if I sell you my used car, that is a sale. It's of goods, right? We'll talk about what a good is. But it's not buyer between merchants. There's no merchant involved. I don't usually sell used cars. You don't usually buy used cars. So the UCC wouldn't apply. But sales isn't the only thing that the UCC governs. If you want to take a look at page, I think it's 35 in your book, there's a list of all of the categories that categories of things that the other articles cover. They cover things like negotiable instruments. What is a negotiable instrument? Well, those are things like checks and bonds, maybe even CDs, those kind of things. That's a negotiable instrument. An instrument is a document that represents value, and negotiable means that you can trade it, that it's something that you can freely trade. So is an IOU a negotiable instrument? Probably not formal enough, right? But there are notes. If it rises to the level of something you actually wrote down and you intended for it to be tradable, then that might be a negotiable instrument, and that's governed by a different chapter of the UCC. There's also sections on banking and letters of credit and secured transactions. Secured transactions, those are things like mortgages or car notes, right? Where when you buy something, you give the lender a lien on the thing you're buying to secure that transaction, or you give them a lien in something else to secure that transaction, so that if you don't pay, there's some collateral they can go take, right? So those are all items. There's other issues covered by the UCC as well, but primarily what we're going to be talking about is Article 3 that has to deal with sales. Article 1 is an important article. We won't talk about it a whole lot, but it's important because it contains the basic definitions, the general rules of construction, those kind of things, right? So as you could expect in any kind of document like that, Article 1 is general, right? There's not a whole lot of specific law in Article 1, but it lays out generally the purpose and a lot of definitions and those kind of things that apply to all of the different articles. Article 2, I'm sorry, I said Article 3. Again, I'm kind of in a COVID haze this week, so forgive me for that. Article 2 governs sales. And Article 2 is, again, probably the most important. It's definitely the most used of the articles relating to contracts, okay? And again, we talked about this a second ago, but now let's get into it. Article 2 specifically applies to the sale of goods. Okay, Article 2 applies to the sale of goods. There's another chapter that applies to leases. That's not Chapter 2. Chapter 2 only applies to the sale of goods. Okay, so if you're not selling something, UCC chapter Article 2 does not apply. All right. If the thing you're selling is not a good, then UCC Article 2 doesn't apply. All right. So what is a sale? Well, a sale is just what it means when you're transferring ownership of something. And what is a good? A good is tangible property. A good is defined in Article 2 as, but it's something that has value and that you can touch and feel and see, right? So if I sell you a used car, that's a good. If I sell you a hamburger, that's a good. If I sell you this pen or my computer or any of those, those are all goods because they're tangible. You can touch them, you can see them, right? You can hold on to them. Those intangible things, though, are not goods. So if Taylor Swift wants to sell you the rights to her music catalog, right? You can't touch that. You could write it down on paper, but that's not really the right. The right is an intangible. You can't touch it. And so the UCC doesn't apply, right? What law would apply? Well, you probably have to go back to the common law, right? Now, there's also statutes on, some federal statutes on intellectual property rights as well. But the UCC, not one of them. The UCC does not apply to the sale of intangible property. It only applies to the sale of goods. All right. Next, the Article 2 generally only applies to contracts by or between merchants. Okay. And you'll see and or consumers. What does that mean? Well, it means that you have to have at least one merchant. The UCC applies to contracts between one merchant and a second merchant, maybe a wholesaler and a retailer, right? Or a manufacturer and a wholesaler. Those are both merchants. It doesn't apply, or it could apply to a contract between a merchant and a consumer because you have at least one merchant there, right? But it does not apply to contracts between just two consumers, all right? One way to think of this is this contract, is this contract in the regular course of somebody's business, right? If it is, that probably makes them a merchant, right? But it means that the UCC doesn't generally, so if somebody's in the business of entering into these kind of contracts all the time, and it's a contract for the sale of goods, then the UCC Article 2 probably applies. But if this is just kind of a one-off contract, then the UCC probably doesn't apply to it. All right. Now, the UCC, again, is a comprehensive statute, very well thought out by a bunch of academics. And so it doesn't leave you hanging with, well, what does it mean by or between merchants? It gives a definition of merchants. It gives a definition of consumers. And you can look those up in Article 2 as well. A merchant is defined as a person who regularly deals in goods of the kind. Okay. A person who regularly deals in goods of the kind. And that's important. It's important to consider that as well. Consider that once a merchant doesn't necessarily mean always a merchant, right? If I go to a used car lot to buy a used car, am I buying that from a merchant? Well, sure. A used car lot, if I'm buying a car, a used car lot is an entity that regularly deals in selling cars. And if the contract is about the purchase of a car, then that is a merchant and the UCC applies. But what if the car dealership is getting new furniture, right? They decided to update their offices, and so they want to sell some of their used office furniture. Does the UCC apply to that? Not if I'm the one buying it. Not if I'm the one buying it, because I'm not in the business of buying, selling, and furniture. And even though the car dealership is a merchant when it comes to cars, it is not a merchant when it comes to the office furniture, because they don't regularly deal in office furniture. They regularly deal in cars. So as to cars, they're a merchant, but they do not regularly deal in office furniture. So they're not a merchant when it comes to terms of a contract to sell office furniture. Does that make sense? All right, so UCC Article 2 only applies to contracts for the sale of goods by or between merchants and consumers. You got to have at least one merchant in order for the UCC to apply. And then what is a consumer? Well, that could help, right? I mean, if you can identify that both parties are consumers, then you know neither one is a merchant and the UCC doesn't apply. Well, the UCC identifies consumer too. Consumer means an individual who enters into a transaction primarily for personal, family, or household purposes, right? You can think of that as an end user. A person who enters into a transaction primarily for personal, family, or household purposes. So if I'm going over to the car dealership to buy a car just for my own use, then I am a consumer. If I'm going over to the car dealership to buy a desk, right, because they're selling out their office furniture, then I am a consumer. Is everybody who buys a car a consumer? Not necessarily. What if it's the car dealership buying cars from Ford or GM, right? In that case, you'd have two merchants, GM, Ford. They are both regularly in the business of buying and selling cars. The car dealership is also a merchant, right? Because they're regularly in the business of entering into transactions for cars, right? So in that situation, you would have two merchants if Ford is selling cars to a dealership, or if a dealership is selling cars to a Hertz rental company, right? Those would be two merchants. So, all right. So it's important to understand that Article 2 only applies, of the UCC, only applies to the sale of goods by or between merchants, right? You got to have at least one merchant involved in the sale. Now, there are other articles of the UCC that apply. Again, look at page 35 if you want all of them. In fact, if you had a quiz on your test this week and it asked for some other areas that the UCC applies, maybe you might want to look on page 35, hint, hint, right? But like Article 3 deals with negotiable instruments. We'll talk about some of these articles real quick, and then honestly, we're not going to talk about most of them for the rest of the year, for the rest of the semester. If you were in law school, you might take a separate an entire semester on each one of these articles, right? If you were, most law schools do 2 years on contracts. I'm sorry, do 2 semesters on contracts. And so the UCC's Article 2 is a big part of that. But then you would take another semester on Article 3, negotiable instruments, or the article on secured transactions, those kind of things. I certainly did. I took about 4 or 5 different semesters, I guess, altogether on UCC articles, including those 2 semesters on contracts. But let's go over just a few of them real quick so that you know what they are, just so that you're familiar with the UCC. Article 3, again, deals with negotiable instruments. Again, negotiable instruments are things like checks and bank drafts, those kind of documents that represent value that you can trade to one another, right? Do y'all still use checks? Are you too young that you don't do that anymore? Has your grandmother ever sent you a check for check for your birthday, or have you ever had a job where you still got a paper check? When you look on the lines, you see it doesn't say pay to Professor Watson. It says pay to the order of Professor Watson. What does that mean? It means that I can negotiate that instrument. I can trade it to somebody else. I can give that. If I transfer that check to somebody else, if I endorse it on the back and give it to them, then they can go cash it, even if they're not me, because I endorsed it. I negotiated it to them. That's an interesting area of law. We could do a whole semester on that alone, but that would be Article 3, negotiable instruments. We go down to Article 9, secured transactions. It's a very important one. Very important for how and when you can establish a security interest in something. When do you have a lien on something, right? When do you have a property right? When do you have a right to go take something if somebody doesn't pay their debt, right? And if they don't pay their debt, what are your rights exactly? That's all governed by Article 9 of the UCC. Again, only applies in certain situations, but it's very important to know, especially if you're working in an area like bankruptcy or debt collection, etc., or even lending. UCC Article 9, very important. There's several others outside of the UCC, right? There are statutes that govern real estate transactions, right? Real estate, for instance, is heavily regulated. It's always governed by other statutes. In Texas, we have the property code, but then you may also have federal legislation that has to do with lending or the environment, pollution, those kind of things. So real estate transactions, heavily regulated, not by the UCC, but that's another source of other statutes, right? We're talking about sources of law sources of law that affect contracts. Again, the general rule is you start with the common law. But then if there's a statute that replaces the common law, then the statute controls. And the mother of them all is the UCC. That's the big one. But there's also other statutes that you sometimes need to be aware of, like real estate statutes. Uh, uh, Here's some examples of federal and state statutes. The Fair Housing Act, right, is a federal statute, has to do with real estate, specifically with residential real estate. There's the Interstate Land Full Disclosure Act. The Real Estate Settlement Procedures Act has to do with how you close on sales, right, when there's money lending involved. There's environmental laws, banking and finance, and mortgage laws. If you look at the state, on the state side of the books, there's things like the statute of frauds. There's landlord and tenant law. States may have their own financing and banking laws, right? Again, the Texas Property Code, that's a huge source of, we've got a whole code that deals with just real estate and real estate transactions. So even if the UCC doesn't apply, be aware that you need to check your statutes and see if there is some other statute that does apply. Now, we're going to talk about the UCC a lot this semester. Because the UCC is very important, and because the UCC often rears its head, and we need to know when the UCC applies and when it doesn't, and we need to know the difference between the basic common law or the UCC, right? These other areas like lending and finance, or intellectual property, or antitrust laws, Deceptive Trade Practices Act, employment law, right? There's a whole employment code. We need to know about all those statutes generally if we're working in those areas. But there's just so many of them, and there's just so many of them, and they're so random and so few and far between that we can't possibly cover all of those this semester. All right. So for those kind of things, you'll have to wait until you start working in one specific field. If you go to work in an HR department, right, you'll become much more familiar with those employment statutes. If you go to work at a title company, then of course you'll become much more familiar with those real estate related statutes and those lending statutes. But we can't possibly cover every single one of those, especially not in just one semester. But what we can do is we can talk about the UCC because there's a lot of times where even in just regular everyday run-of-the-mill contracts, your very first question is, does the UCC apply here or does the common law apply here? And if so, what's the difference? So we'll talk about those this semester. All right. Let me throw this back up here real quick. Under sources of laws, it's not just statutes, not just common law. We also have things like international law. You may need to check the law of various countries, right? I mean, if you're entering into a contract with somebody in Brazil, you may need to know what Brazil law is on that. Or you may need to see if there's any kind of international issues, international relations. Are there any treaties? Are there any UN conventions? Have those treaties been ratified by the United States? Maybe, maybe not, right? Does that mean they don't apply to you? Well, if you're doing business with somebody in Brazil, and Brazil has adopted a UN convention, but the United States hasn't, well, then if you sue somebody in the United States, maybe it doesn't apply. But if you have to go down, or if you get sued down in Brazil, then you may need to know about those international conventions as well, right? That's beyond this course. If you want to take an international law course, highly recommend it. It's extremely interesting, but it's also a very narrow, even with as much trade as goes on, it's a narrow field. It's not nearly as common for you in just your everyday practice to run into international contract issues. Beyond the common law, beyond the statutes, another source of contract law are administrative laws. What are these? Well, these are rules and regulations, right? They're not statutes, not things that have been passed by the legislature and signed by the executive. But many times the legislature will create an agency, and they will give that agency the power over some area of the law. And as part of that, they will give them some rule-making authority, okay? And we call those, when an agency just creates a rule or regulation, they don't have to pass that through the legislature. They don't have to get the governor or the president to sign it. The legislature already passed a law that set up the agency. The governor or the president already signed that law. And if that law gives the agency the power to make regulations in a specific area, well, then you may need to check those regulations as well. Again, there are a ton of regulations that it would be impossible for us to even probably even to list all of them in a semester, much less to learn them all. But here are some examples of some relevant agencies. There's the Federal Trade Commission, right? That's a federal commission that deals specifically with commerce. It's right there in the name, trade, right? There's the HUD, Housing and Urban Development, right? There's the FCC, the Federal Communications Commission. There's the Security and Exchange Commission. There's the EPA, the Environmental Protection Agency. There's OSHA, the Occupational Safety and Health Administration, right? What does it have to do with contracts? Well, a lot. They have to do with office safety. And if you're entering into contracts, there are some OSHA regulations that may limit what you can and can't do. There's the EEOC, the Equal Employment Opportunity Commission, right? There may be EEOC regulations that deal with what you can and can't put in your employment contracts. All right, so there's lots of agencies that may touch on different areas. It's important to understand that they're out there. In case you're working in that field, then you need to become more familiar with those regulations. But again, those are things that we probably can't become experts on those in just one semester. So be aware that they're out there. You could take an entire separate semester, or you could spend years of your career becoming an expert in FTC regulations or OSHA regulations or in employment law, EEOC regulations. If you need them, let me give you a few resources. We won't talk about them much more this semester, but I do like to give you guys resources that will help you when I have them. It's easy to find, or at least once you take legal research and writing, once you've got some experience, it's easy to find the common law. It's exceedingly easy to find statutes. I gave you that Capital Texas Statutes website. It's exceedingly easy to find statutes. Regulations, not so much. Regulations can be very hard to find. They're typically not ordered nearly as well as some codes, some statutes are, and they're not published the same way, and so they can be very much harder to find. Federal regulations, regardless of what agency or what office passes a federal regulation, federal regulations can all be found at one place, and we call that the CFRs, the Code of Federal Regulations. And I've given you a direct link there. There are federal regulations on everything from taxes to employment to OSHA to you name it, right? There are a million regulations out there, but typically you can get to them all in the same place. They're in the Code of Federal Regulations. Those are published by the Government Printing Office. And an easy, free way to search those is at that website there. Of course, you can look on Westlaw, those kind of things as well. Texas regulations are even harder to find, but they're in the Texas Administrative Code. Okay, so don't look at that Capital Statutes website because they're not there. Regulations are not statutes. The Texas Administrative Code can be found at that website on your screen. You may want to copy that down. I'm telling you, every time I give you a website, it's because these are things that I use, sometimes daily, but daily or weekly or at least monthly. These are things that I use just all the time. And if you become a practicing legal professional in Texas, you're going to need them too, right? So write these down, save them. We probably won't look at many regulations in this class this semester, but at some point in your career, you're going to need to find federal regulations or state regulations, and now you've got a link to where they are. All right. Also, many of these websites, they have their own websites, and so you can sometimes go to their own websites and get links to their own statutes, right? Like the Texas Education Agency, right? They have rulemaking authority. If you go to the TEA's website, they've got links to their regulations, not to all the others. They may or may not be better organized on their own website. But if they do, that'll be the same regulations that are contained in the Texas Administrative Code, or if you're looking at a federal agency, those will be the same regulations that are contained in the CFRs, the Code of Federal Regulations. Lexis and Westlaw, powerful tools as well. Sometimes a simple Google search will get you what you need even faster. But as you can see, as you get farther and farther away, as you get less and less specific, you can imagine if I told you right now, okay, well, just go find the statute or just go find a regulation on Google. You'd be like, oh my God, if I search something on Google, there's no telling what's going to turn up. I wouldn't even know how to narrow it down to where I was just getting the text of regulations. So if you know what you're looking for, great. Go straight to go to Google and look it up. If you need something more directed, look at the website for the CFRs, the Texas Administrative Code. Go to those individual agencies. That may be an easier way to get into it. Okay. Here's a practice tip. And this is important. This is not in your book. This isn't something you'll be tested on. This is something for you all. I assume that you're all taking this class because at some point you want a job, right? You're not just taking this class to be smarter, to be better educated. Each one of those federal agencies, each one of those state agencies, they have very specific areas of the law. And if you find yourself working in one of those specific areas of the law, then that is your time to become an expert, okay? To make contacts with those agencies, to get familiar with their rules and with their processes. Because if you have that opportunity, you've got a case and you're working on something with the TEA, for instance. If you can make those contacts, if you can learn their process, then you now have an expertise that most legal professionals, and indeed most people, simply do not have, right? If you go to work for a law firm that handles unemployment claims, right, or workers' compensation claims, that's a whole unique administrative process. And if you have a chance to learn that process, to make those contacts, that makes you unique and it makes you valuable. It gives you expertise that most people don't have. All right. So if you get the opportunity to deal with an agency, or if you're working on something that's governed by an administrative agency like that, my advice to you is save those contacts, save those notes, keep that all in one place, aside from just that one particular client, so that you can develop an expertise in that area, in unemployment, in workers' comp, in whatever, because that may make you more valuable and more marketable as an employee later on. Okay, especially if you find an area where you're good and you like it, right? And you've learned how to handle these workers' comp claims, and you know the process, and you know the administrative process. Quite frankly, most lawyers simply don't know how to do that. Most paralegals, most legal professionals simply don't know how to do that. None of the public knows how to do that. And if you develop that expertise, you may make yourself really actually very valuable, very marketable. Okay, so just something to throw in there. Otherwise, let me put one more thing up on the board, and then I think we can get out of here. Again, this is worth reading. State and federal agencies are all unique. They can be terribly important in a given field. And when you have a special understanding or a special relationship with those agencies, with its policies, with its procedures, then you become valuable. And when you can do those, it's a good way to make sure that the place you're working can't fire you because you're the one who knows how to do it. It is also a great way to make yourself marketable to other firms who need somebody who knows something about unemployment law, for instance, or workers' compensation. All right. Whoops. Lastly, let me point this out, and you'll hear me repeat this time and time and time again over the semester in this class or even in any other class. Being familiar, even to the point of becoming an expert on the laws in a given field, will make you more productive and more valuable as a paralegal. There's just no doubt about that. Okay, learning the law, being intimately familiar with it, will make you more productive and will make you more valuable. It will enable you to research more quickly and more efficiently because number one, you'll know where to go, and because number two, you already know the concepts. All right, but, and this is in all caps because I mean it, do not ever believe that you have memorized the law. I'm not opposed to you trying to memorize statutes and trying to memorize case law. But don't ever believe that you have it memorized, because the second you rely solely on your memory, you will be wrong, right? Laws change. Either the statutes change or the judge's interpretation of the law changes, or you're in a different jurisdiction, right? And the law is a little bit different in that jurisdiction than in your jurisdiction, or sometimes you just remembered it wrong, okay? The law changes. So work with the law. become an expert in the law, understand the law. You can even try to memorize the law if you want to. But when push comes to shove, when it's time to start writing something down or it's time to give somebody advice, double check. Always go back and look the law up, because the second you think you start to rely on your memory, man, somebody's going to pull the rug out from under you and you're going to be wrong. Okay. Again, statutes change. Judges' interpretations change, or maybe you just remembered it wrong. All right. So never think that you have memorized the law. Become an expert in it. Be very well read. Be able to recite the statutes if you want to, but before you write a brief, before you give somebody real legal advice, tell them, I think here's the law, but I want to go look it up and double check just to make sure. Okay. I do a lot of probate law from time to time, right? And there is there are the rules of intestate succession, the statute that says if you die without a will, who gets what, right? I've been dealing with that for 20 some odd years. I know what it says. And every time a client calls me and says, hey, my grandmother died, she didn't have a will, who gets her stuff? I tell them my basic understanding, my basic recollection is here's how it goes. But before I give you my final word, let me go look it up. Let me double check just to make sure, right? Just to make sure they haven't changed the statute, just to make sure that that I'm not misremembering as I get older. Okay, so all right, so that's it. You've got a couple of assignments this week. You've got a quiz and a memo. Those shouldn't take you too long. Looks like we've knocked out everything. This is kind of a short chapter, so just one recording this week. But get that knocked out. And then next week, we're going to start on chapter 3. We're going to start on these elements of a contract, and we're going to start with the very first element, agreement. Okay. It may sound very simple, but again, lawyers, legal professionals who don't go back to the basics every single time, those are lawyers who lose. So we're going to get a good, solid foundation in what is an agreement, right? That's governed mostly by common law. This chapter was on sources of law. And so that's governed mostly by common law, but also by the UCC. We'll talk about some of that a little bit. And I will see you next week. Okay. As normal, if you got any questions, give me a call, shoot me an email, send me a text. Otherwise, again, you've got a quiz and a memo. Class notes and PowerPoints should be in the link below, or they should be in your course materials. Let me know if you got any questions. Thanks and have a great week.